Thank you, Presiding Officer. And like others, I welcome this bill having been brought forward, but take no pleasure in the necessity that it should have come to this legislative solution to a problem. It's worth making the point, and we had this from some survivors whom we spoke to, that of course, first of all, not all are looking for a court solution, and there are those for whom there is no resolution, because it isn't simply about institutional abuse. The bill covers abuse by individuals on individual children, and there are cases, obviously, where the abuser simply is no longer around, they have died, and that kind of closure for some survivors simply cannot be given. And I'm very grateful for one person in that position coming and telling their story. Very emotional for the person concerned, very emotional for those of us who heard it, simply because we cannot provide by legislation any way forward for that, and I'm sure other individuals. The courts are one way of getting peace after abuse. The Jersey process that went further back in the calendar than 1964, but in very limited and very different circumstances, did have interest for the committee in that it provided perhaps a quicker way of dealing with some things and a way that was less stressful. And I think there is scope for looking at whether there are ways in which we can, as we move forward, find ways of assisting people by pre-action protocols and perhaps other non-court ways of helping people as well. And I think we should not yet discount that. Now, I do want to just raise one particular thing. I made very brief reference during the committee consideration, but I thought a little bit more about it subsequently. And that is, this is, of course, the limitation of Childhood Abuse Scotland Bill that we're debating. And the introduction talks about childhood abuse. And I just think there is perhaps further scope for our thinking about what a child is, because it is someone who has not reached the capacity of someone of more than 18 years old. But it may also be reasonably held to apply to people whose calendar age is in excess of 18 years old, but they have not got the capacity of an adult. And I simply wonder whether there is the opportunity to make sure that we capture people of a greater age, but a more limited capacity, who have suffered exactly the same kind of abuse. 1.2 defines a child simply as someone under the age of 18, and there may be scope for looking at that again. Not something the committee has considered in detail, so I will understand if we can't see where that goes forward. Now, the discussion that the committee had and the way the bill is structured, it does make clear, of course, that we have to look at the circumstances of the abuse in the light of what the legal and practical position was at the point abuse took place. Now, that is, of course, a difficult issue, because it almost means that we're endorsing abuse that we would now castigate in law and in practice and in moral code, which we might not have done at the point the abuse post-1964 is covered by this Act. But I see no resolution as to how we can properly do that. The issue, too, of a nugatory financial settlement that may have been made, perhaps for £1, although it's fair to say there seemed to be no evidence that any such settlements were of a nugatory nature. So perhaps it's only an academic issue. But I think the principal point that once you start to include where there has been a financial settlement and reopen that, there are real risks to the bill's legitimacy as a whole that I think I have ultimately, not initially, ultimately been convinced is cast in the right way. It is, of course, a very simple bill in the sense that it covers two sides of paper, but the complexities of the legal issues that are contained within it are much more substantial than the limited number of words that are. Now, there's been a little bit of reference already to the financial memorandum and to the uncertainty as to the number of people involved. I think the Minister's response to the committee has simply said there are other views, and that is correct. But all the views that can be expressed by various people are no more than that. No one actually knows. And I think we've got to step above a rather pointless debate about numbers and say this is a principled matter where we wish to support people who have suffered childhood abuse. We simply have to deal with the practical effects of that when we come to them, while making a proper initial provision to cover what we think is a middle point estimate. But don't let's imagine that we can keep looking at this and find some magic certain answer. I'm convinced, and I think others are, that there ain't one to find. We do this as a matter of principle, not as a matter of money. Presiding Officer.